Fuzzy.
From the Sunshine State, this is Tampa Bay's Tan Talk.
It's time for FLA Law, brought to you by the personal injury attorneys of Perenich, Caulfield, Avril Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
Good evening. It is Tuesday evening, and that means you have another edition of FLA Law on the radio. This is attorney Matthew Noyes, and I'm one of the partners at the law firm of Perenich, Caulfield, Avril, and Noyes, a personal injury law firm here in Clearwater and throughout Tampa Bay that has been serving the injured since 1955. We are the oldest personal injury law firm in Tampa Bay, but we are also proud to host FLA Law every Tuesday to give back to the community, to be able to answer the questions that you may have regarding the law. As you know, we do personal injury, that's car accidents, trip and falls. We also do work injuries and Social Security disability as well. So we're happy to tackle those questions. But if you have questions outside of those areas, that's what this hour is for, to be able to answer the questions that you may have without you having to have the concern of talking to a lawyer or paying for a lawyer to have a question answered. So this is a live call-in show. It works a lot better when we do have people calling in with questions. So if you do have a question, call the law line at 727-441-3000. We are here from 5 until 6 today. And I say we because I'm not here by myself. I have my friend and my law partner, Lori Robinson, here again, available to answer questions that you have as well. So, Lori? All right, it's good to see you again.
Yes, likewise. A long time no see. Always good to be on the show. And, I do think it's helpful, even if people sometimes don't call in. I'm aware that people will listen. And there's so many times that there's a question a person has, a legal question, and it's so difficult to get those questions answered.
Right.
It's surprising, actually, what it costs to go get a question answered. So a lot of people don't even make the effort because they feel it wouldn't be accessible to them. So we like to talk about the areas we know the most about, but since we've both been practicing law for quite a few years, right, I'll take a stab at almost anything.
That's me too. And if I can't take a stab at it, I'll be happy to lateral it over to you, Lori. So if you have questions, call us, Lori and myself, at 727-441-3000. But if you say, hey, listen, I don't want to hear my voice on the radio, we are also live on the law firm's Facebook page. We are streaming live at the page of Perenich, Caulfield, Avril, and Noyes Injury Lawyers. That's Perenich, Perenich. But we're streaming live, so if you want to type in a question in the comments, don't hesitate to do that. And we're happy to address those questions on Facebook as well. But for the first half of the show, or somewhat half of the show, Lori, I thought it would be good. Last week we talked about all these new laws that came into effect.
That was pretty interesting, actually.
And it was pretty good. As you were saying, we may not have someone calling, but we know that they're listening. I had somebody say, hey, I didn't even know about that law that we talked about. I think it was the balloon one that we talked about.
Right.
And I said, well, I'm glad you listened to the show. Now you know something.
And how about the right to defend yourself against a bear attack?
That's right. That's important too. But so what I want to do tonight is to really talk about law in the news, in essence. There's all kinds of news going on.
Oh my goodness, yes, there sure is.
And we could spend 24 hours a day for 7 days a week probably talking about the impact the law has on whatever news is being generated. But really what I want to focus on are, things that impact that have happened in Tampa Bay, and how we as personal injury attorneys who see these things every day and how they impact people every day, how hopefully us talking about it may prevent another tragedy from happening. Mm-hmm. So the first one I want to talk about is the DUI crash that happened in St. Petersburg. A 2-year-old child was seriously injured in the DUI crash last Friday evening. At about 11:30 at night on Friday, July 5th, a 33-year-old woman from Pinellas Park was driving. She was swerving within its lane and did not have its headlights on. It crossed the opposite lanes and crashed into a large tree on Martin Luther King Jr. Street.
Mm-hmm.
Sadly, the 2-year-old passenger was improperly secured in a child safety seat and was ejected from the vehicle.
Oh, gosh.
The child was transported to Johns Hopkins All Children with serious but non-life-threatening injuries. Thank goodness.
That's good. Good to hear that.
The driver was transported to Orlando Health Bayfront Hospital and showed signs of impairments at the scene and was subsequently arrested. The driver was charged with DUI, causing serious bodily injury, child neglect, reckless driving, causing serious bodily injury, and possessions of controlled substance.
Oh, a little laundry list there for sure.
The story just concerns me. You have a 2-year, it's DUI, which is crazy. We have a 2-year-old that's out on Friday night at 11:30, and we have improperly secured in a child safety seat. Well, the child should never have been. I mean, I don't know what the relationship between the driver and the child was, but assuming it's the mother-child, I mean, to put that child at risk is sad, really.
Well, I think we can presume the old public defender in me coming out is that the mother probably has some substance abuse problems, because that to have your child out at that hour, obviously having had too much to drink, and apparently some other controlled substance, drug in the car, not sounding good. And that mother's going to have a lot of interaction with the legal system. If she hasn't already, she's going to have quite a bit as a result of this incident.
I mean, she injured a 2-year-old child. I'm not sure if it was hers. But imagine she's driving with no lights on, going the wrong way. We see that way too many times. We see crashes involving DUIs causing very significant injuries in car accidents, all because somebody was dumb enough to get behind the wheel after a DUI.
The whole essence of what we do is deal with injuries that come as a result of negligence. And so obviously in this situation, it's rather classic to you
can be more negligent than getting behind a wheel
when you've had too much to drink.
Right.
And that's really a very bad idea.
And that actually borders on recklessness and partially and possibly could lead to punitive damages as well.
In the civil context, absolutely. And if there had been, say, in this situation, thank goodness, apparently the child did not have life-threatening injuries. But if the child had died, then you're talking about a DUI manslaughter,
right?
With criminal implications. Now we're dealing with the civil implications. When you have facts that are pretty outrageous, that almost make you think, my goodness, this is practically a crime. Is a crime, then that's where punitive damages can come into play in the civil system, which are damages intended to punish the particular driver. Now, as we know, in the civil context, insurance does not normally, in fact, does not cover punitive damages. Right. So that's the kind of thing, unless you are suing somebody that is actually a large company or something, have some place where there are financial resources, then there's not that much you're going to be able to do in a civil system.
And it's not really that easy to get punitive damages. We have been representing people after car accidents for decades, and many times we hear a client say, I want them to pay for what they did. I want them to pay punitive damages. Well, if it's a quote unquote standard automobile accident where the person was speeding or improper lane change or improper turn, punitive damages aren't recoverable in those situations.
Right.
And so we have to educate our clients that the damages that they are entitled to after an automobile accident are really compensatory damages, to try to compensate them for the damages that they have, and not necessarily for punitive damages.
But when something is pretty egregious,
sure,
that it does kind of play into how it's looked at. And so even though you can't expressly recover punitive damages, if the negligent party has engaged in conduct that is pretty outrageous, those are things that play into our ability to get a case resolved in a settlement. And if a case went all the way to a jury trial, potentially would have somewhat of an effect, although not the way the client is thinking, potentially with punishing in the sense of punitive damages. But if you go to a jury trial, they do hear, generally speaking, what has occurred, and that can have an impact on how people look at the case.
Now, there are some times when we go to a jury trial that the defense attorney or the insurance company admits liability.
Yes.
Can you explain to our listeners, what admitting liability means and what impact that has? So
even take the case we're just talking about here, where we don't know, we could presume it could be the mother, but maybe it's just a friend of the family, who knows? But say a claim is brought on behalf of that child, if it's not the mother, against the driver. In that scenario, no lights on, driving under the influence, they don't really have any argument to defeat liability, which just means responsibility for the accident. So in that situation, if there's insurance, the insurance company hires a lawyer to defend the person that caused the accident. The insurance company is going to admit responsibility for the accident to prevent us, who represent the injured party, from bringing out all those egregious facts that I just said a moment ago. Even if you can't get punitive damages, if people hear a story that is outrageous, it makes them pretty mad, and that can have an impact on the damages. So the insurance company is going to admit liability, responsibility for the accident. What they won't admit is responsibility for the extent of the damages. And so that will be the argument about what are those compensatory damages in the particular case. Yeah, the insurance company is not doing us a favor or a client a favor, saying, oh, well, we admit that we are at fault. Really what they're just trying to do is prevent the jury from fully understanding the facts of the case. All of the circumstances, right? And then they attack on pre-existing causal connection between the injuries and the accident. And really our clients feel like they're under a microscope. We hear that all the time. Yes. You feel like you're on trial yourself, and here's the person who did nothing. Like, take a typical accident that's a rear-end collision, happens all the time. You didn't do anything. You're just sitting at a light and somebody rear ends you. And yet your life is subject to a lot of scrutiny. Yeah, and the at-fault driver often doesn't even know what the insurance company and their lawyers are doing. Right. They're off living their lives, doing what they need to do. And our client is stuck having to fight for damages, having injuries, and being under the microscope of insurance companies, investigators, surveillance people, and defense attorneys and insurance companies. It's not the fairest system in the world. Now, of course, we're there to help the person through it, and I don't want to scare anybody off with this, because on the other side of the coin is the insurance company that hires a lawyer to represent the party that caused the accident. They are investigating the case, and they're going to defend in our adversarial system. They're going to defend that driver. Now, of course, obviously the insurance company's interests are to minimize the amount of damages that could be awarded. Right. But that's not illegitimate for them to do that. But it sure does feel very invasive for a client. And we are able to protect the client through the process from it being any more unduly invasive than it already is, and to kind of prepare people to know what to expect. There is surveillance, as you mentioned, occasionally. Not as often as people would think, but it does happen. Right. And that really is invasive. Right. You're thinking, really, what is this, like the Rockford Files or something? Yeah, and a lot of times they try to do that surveillance, and it just doesn't show up anything that's hurtful to the case. And you and I, we always tell our clients the same thing. Do what the doctors tell you can do, and be honest. Right. To the doctors, in your deposition, to us, just be honest, and then there's really nothing you really have to worry about. And then most times it's really not even a problem, But if you say you can't do something and they film you doing it, well, that's a little bit of a problem. That's a problem. That's right. All right. So if you have any questions regarding punitive versus compensatory damages, or just bringing on a case and going to a jury trial after an auto case, give us a call. This is FLA Law on the radio. This is a live legal call-in talk show.
And so in order to have the call in, we need you to call in at 727-441-3000. While we wait for our caller, we'll keep with the legal talk show part of it.
All right.
And talk about another accident that happened in St. Petersburg on Friday. The day after a holiday,
yes,
a weekend,
4th of July weekend.
Yes, it's sadly a lot of problems happened. Well, on this Friday, at about 7 a.m., shortly after 7 a.m., a Dodge Journey struck a bicyclist at 16th Street North and 5th Avenue. Sadly, the bicyclist later died at the local hospital. According to the investigation, the Dodge was traveling eastbound on 5th Avenue North with a green light and attempted to turn south onto 16th Street North. At the same time, the bicyclist, age 83 years old, was crossing 16th Street North from east to west in a marked crosswalk with the right-of-way. The Dodge driver failed to yield and struck the bicyclist. The bicyclist was not wearing a helmet at the time of the crash. Sad case.
Very sad.
Sad case. A bicyclist passed away. An 83-year-old bicyclist passed away. And this driver, we were kind of talking about the difference between recklessness and an accident.
Mm-hmm.
And it sounds, from at least this newspaper article, is that this was one of those things that was an accident. The driver, I think it sounds like he was turning left, if I knew my directions correctly.
I'm trying to visualize that, and he just wasn't paying enough attention.
Saw that there's no cars coming and didn't appreciate the bicyclist. But this accident kind of helps us and our listeners, to be reminded of the importance of bicyclists on the road. I mean, we live in Florida. I mean, there's a lot of bicyclists, a lot of pedestrians.
And I have to say, a person that's bicycling at 83 means he was in very good shape, most likely. He rode his bicycle a lot. He probably was pretty careful, so, kind of reminds me of a case we had some years ago with another gentleman that was not quite as old, but he was up in years. Same thing, rode his bicycle, and he got very seriously injured. Thank goodness he did make a good physical recovery. Ultimately, we were able to make a good financial recovery for him, and he's such a nice man.
Right.
Yeah. So but it's so hard. Drivers really should. I mean, we know because of what we do. I mean, I'm always looking to be sure of what's in my surroundings, but people are not good about that.
No, and it's sad. I mean, in that case that we represented him, he was a great guy. He was up in Newport Richey.
Yes.
And if I remember the facts correctly, he had the green walkway, and so he was crossing the street. And I think it was a Frito-Lay truck.
Big truck that was
Frito-Lay truck was turning right.
Yes, and just didn't see him.
And looked to the left to make sure there was no traffic coming towards him. And he was turning right on red, which he's permitted to do. But he didn't see our bicyclist, and he ended up running over our bicyclist.
Really very serious accident.
So fortunately, and so that accident and this accident just that resulted in the fatality on Friday just reminds all us drivers, that we need to be careful when we're making any turns, to make sure that there's pedestrians and bicyclists that, bicyclists have the right of way.
Yes, and we have a lot of bicycles, and I know people can get kind of annoyed with it in a certain way when they're driving, but you think about Florida, and we have weather. It's pretty hot right now, but I mean the weather that allows you to be outdoors, and people that maybe for a variety of reasons do not want to be driving. They want the exercise, or maybe that's their only transportation.
Right.
So it definitely is something people need to be very tuned into.
And when a bicyclist is injured in an automobile accident caused by another driver, the bicyclist has entitlement or rights to the driver's automobile insurance for medical bills.
Yes, for the PIP.
For the PIP. And I wanted to really talk about that because it's a little bit different.
Right.
In Florida, under Florida law, if you own a car, you're required to carry PIP or personal injury protection coverage that provides medical care up to $10,000 at 80%, whether or not you caused the accident or not. Now the question is, if you own a bicyclist and you don't own a car, and you get hit, why don't you tell our listeners, what rights does the bicyclist have in getting their bills paid?
So in that scenario, and we see it all the time, which, often, fortunately, the accidents may not result in death, but maybe a significant injury. So if you do not have your own vehicle, which would mean you would have to have your own PIP, and you're in an accident while riding your bicycle, and the accident's with another motor vehicle, you will be able to make a claim under that at fault driver's PIP insurance. So you'll have your bills covered up to the $10,000, 80% up to $10,000. In that scenario, you would even potentially be able to make a claim for wage loss within that coverage. But the main thing that it does is that if you don't have any other sources to pay for the bills, you would have that.
Right. And I think it even covers it if the bicyclist was at fault, because it's a no fault.
Yes, that's true. That it would be true because that type of coverage, that's where everyone thinks that they have this great quote full coverage, but that full coverage really under the no fault law is just designed to be sure that those medical bills that you might have in a relatively smaller accident will be taken care of. So it doesn't matter who's at fault. So you're exactly right. It would be available regardless of whether the bicyclist had some fault in the accident.
Now, what if the bicyclist was riding his bike and gets involved in the crash, and he does own a vehicle and he does have auto insurance on the vehicle, but he wasn't in the vehicle at the time of the crash? Who pays his bills?
I think in that sense, it would still be his auto.
It would be, it would be his, even though he wasn't in the car.
Right.
And that's kind of, we hear a lot from clients. It's like, well, wait a second. How come my car insurance has to pay if I was a passenger in my friend's car?
Right, because
and welcome to Florida law.
It just doesn't seem like it's fair to people, and then people understandably worry about an impact on their insurance rates if a claim is made. But that is what the PIP insurance is for: is to take care of your auto-related medical bills,
without having to bring a lawsuit or a claim.
Right.
And that's what the purpose of that is.
That's the purpose of it. It's supposed to be smooth and easy and efficient. Not quite.
No. All right. So that talks about the bicycle accident in St. Pete. So it does free up some time. If you have a question regarding bicycle accidents or car accidents, or who pays your bills after a car accident, that's what Lori and myself, Matt Noyes, is here to do, to answer your questions that you may have. So call the law line at 727-441-3000. Before we go down to the next one, I did want to jump back to the bicyclist accident, because some people don't appreciate that a bicyclist and a moped and a scooter are all different. And if you get injured on a scooter or on a moped, you would not be entitled to the at-fault driver's PIP coverage.
Yeah, that's right. That's right. I wasn't even thinking about that. And there's all these
exactly how many cc's of the motor vehicle had and such like that.
It's like, I wonder what the basis for that distinction is. I don't know.
And actually, we even looked it up. We had a case where they were on one of those like skateboards, I guess they rent or something like that. And it's because it's a motorized vehicle, so to speak. It's not covered under PIP. So it's crazy. It's crazy. But let's go to the next law in the news. And this has to do with the Hillsborough deputy that was run over by a vehicle and severely injured. This happened again on July 5th at 12 o'clock midnight. Hillsborough County Sheriff's deputy attempted to make a traffic stop on a black BMW. The suspect fled the traffic stop at a high rate of speed. At 12:25 a.m., the deputy attempted a second traffic stop for the same vehicle. When the deputy exited his vehicle, the suspect ran him over and fled the scene.
Oh, gosh.
The deputy was transported to Tampa General Hospital with a fractured leg. I think I saw in the news that he was discharged yesterday or something. So he is doing okay after that situation.
It's such a difficult job.
Yeah, it's a difficult situation. So this really tells me, as personal injury lawyer, it makes me think of several things. That's a workers' comp claim. Right. It also can be a liability claim. I think this person was DUI. So probably no insurance. I doubt there's any insurance. But it also reminds me about the move over law. So why don't you tell our listeners a little bit about, when you could have both a workers' comp claim and a third-party claim?
Whenever you have an injury that occurs while you're working and it's caused by a third party.
It has to be a third party.
Yeah,
That's what's important.
It can't be like a coworker or somebody involved in your work setting, because the workers' comp system is designed, once again, it's supposed to be very efficient, and you don't have to deal with who's at fault or anything. You're injured at work. Your bills will be paid under the workers' comp fee schedule. You go to their doctors. All's fine. At least that's the assumption there. So,
right. And in exchange for that, they take away your right to bring a lawsuit against your employer.
Right.
Even if the employer was negligent, you don't have a right to bring a lawsuit against the employer.
And that's there are a lot of reasons behind all of that, but that has resulted in a lot of injustices over time. I mean, I guess you could say maybe it's in theory balanced by situations where the employer really isn't at fault. Accidents occur, but there have been some egregious cases that we've been involved in over the years.
And how many times have we heard our clients say, "Oh, my employer's mad at me because we're suing them." Right. It's like, we're not suing them.
Not in the workers' comp system. That's
I always say that the employer should love us, claimants attorneys, because we're fighting for their good employees who get hurt. Mm-hmm. Our job isn't to sue the employer. Our job isn't even to sue the workers' comp carrier. Our job is to get the benefits that injured worker needs to get back to work.
Right.
And the employer should love us for that.
Yes.
But, the insurance companies are pretty persuasive to try to make us lawyers look like the bad guys.
And just the mentality, they just don't want to pay. So instead of getting it should be whatever that person needs medically. Isn't it amazing when you'll have situations where the client says, "No, I still am having these issues." Okay, well, address it. But they don't want to. Some of the companies do better than others, obviously, but
in a workers' comp law, the insurance companies don't utilize it like they probably should. But there's a period of time. It's a 120-day pay and investigate period of time, where if they really think that it's not a workers' comp claim or the injury is pre-existing or whatever it may be, they're allowed to, they're instructed to pay the workers' comp benefits for up to 120 days before they can say that it's not related.
Gives them time to investigate it if they think there's some question about it.
Without any penalty. Just because they paid doesn't mean that they said that it is work comp related. But instead, they, in some situations, they just deny without investigating. It's supposed to be pay and investigate, not deny and investigate. It just drives me crazy that there's a provision right there that they can get what they need to get, but not at the expense of somebody who needs medical treatment and is not working and not getting wages.
That's so key, getting the medical treatment at the earliest opportunity when it can do the most good. How many times do we have situations where people are strung along for so long a period of time that the benefits of physical therapy and other things,
it's one step forward, two steps back. We see it all the time. We have clients saying, okay, they're recommending physical therapy, they're not authorizing it. We have to file a petition. We have to do a good faith letter, then a petition for benefits, and then finally they agree to do it. Well, the physical therapy isn't going to be that helpful.
The best time to do it is, right at the time or the injury is fresh.
It's 90 days later by the time you get the physical therapy authorized. But this deputy does have a workers' comp claim.
Right.
And he's entitled to, under workers' comp, he's entitled to medical by the workers' comp doctors and wages for a certain amount of time and at a percentage. What if there was a third-party claim? What other damages would they be entitled to?
If this was a situation, say it had just been an automobile accident that he was in with some other driver, not someone that is kind of a criminal, it sounds like, obviously, so in that scenario. So if there was a party who was financially responsible because they had insurance, then the kind of damages you can get in that scenario are your medical expenses. But of course, in this situation, the workers' compensation carrier is paying those. But it's much more restrictive than what you would be able to recover and obtain in an actual legal claim that isn't hampered by the workers' comp restrictions. And in addition, the biggest thing really is you can recover for the emotional pain and suffering, the emotional distress, the intangible part of going through an accident that causes injury, that you can't recover at all in workers' comp. In fact, you can't really ever recover a lump sum for reflecting your overall damages from workers' comp unless you enter into a settlement with the carrier and usually are required to resign. So you have to be ready to end your relationship. And that settlement is never going to include one dime that's related to the emotional distress of going through and the pain and suffering of going through.
We always told clients not a penny for pain under workers' comp, not entitled to it. And that's why that if there is a third party claim, that they can be compensated for their pain and suffering and other intangible damages.
Right.
They could also, under workers' comp, they only get 66 2/3 of their wages. And the third party claim can make up that difference. Yes. And we have represented a lot of people in a workers' comp claim that they can't go back to their line of work. I've represented a lot of nurses that hurt their back helping patients and they can't go back to nursing. Mm-hmm. They have to accept a job that is lower pay. In a workers' comp arena, workers' comp doesn't have to compensate for that loss of earning capacity.
Right.
If there was a third party claim associated with that, then that third party claim would be able to include the loss of earning capacity as well.
Which could be a very significant thing, particularly in those settings where you have people that have worked in physically demanding jobs. They've been injured on the job. They're not going to be able to return to that type of work.
That's right.
So they're going to have to find something else. So that's a situation where they may end up benefiting from entering into a settlement agreement because they aren't going to be able to continue to work in that environment. So that's an option for them. But all of the damages that have to do with now their lifestyle is permanently changed. They're not able to do the type of work they train for. They're going to have to get trained perhaps for a whole new area. Expenses associated with all of these things only could be recovered if there was somebody outside of your work environment that was responsible, the third party, and they were financially responsible.
Right. And we at Perenich, Caulfield, Avril Noyes, we handle the auto case as part of it. And we also have a workers' comp department where we can handle the work comp aspect of the cases too, because it's important that both sides are working, both claims are working with each other in order to maximize the recovery for the injured person. In fact, we handle a lot of workers' comp claims for other personal injury attorneys in the area that are handling the third party case.
Yes.
And we just think it's important and that both sides are working together to make sure that they're fighting to get their client all the intangible damages and the liability and such like that. And we're making sure that the workers' comp carrier is providing what they're supposed to be providing. And then there's the whole workers' comp lien that comes into play as well. The workers' comp gets to knock on the door if there's a recovery from a third party and say, oh, thank you very much. I know we sent you to our doctors and we paid you a portion of your wages, but now you have to pay us back.
Right.
And so we work with the other side too, And it's
it's a negotiation, but it's based on kind of a little niche area of the law, kind of complicated formulas that are associated with how workers' comp looks at things. So if you aren't familiar with that area of the law, even though you do personal injury, then you're going to miss some of the nuances there. So it's one of the things I know you started the show by saying we're the longest established and all of this, and which I really think that's fantastic because it gives us such a broad depth of experience. But then on the other hand, we're also very up to date, have all the modern technology. We're on Facebook, we're on YouTube, we're all this. Now I don't do the what do they call it? Don't we have a TikTok thing?
I understand we do have a TikTok thing. I have been victim of, hey, Matt, do this weird thing, and we'll put it on TikTok, and I have agreed to do that. So, but I have yet to see me on TikTok. But my son has seen me on TikTok, and he says, Dad,
oh my!
Don't put your name on there, please. All right. No, I'm teasing. No, we do have TikTok.
Yeah.
But it does give us an opportunity for being around for so long that other firms trust us to handle claims that they otherwise couldn't handle, but also our clients trust us. I mean, most of our clients, our present clients, come from past and present clients. Mm-hmm. And that's because we just believe it's important to give them the service that we expect from ourselves.
Yes.
And we're proud to be in existence for as long as we can. But it does free up the next news article. But before I go on to it, I did want to, again, open the lines up to our listeners. The telephone number is 727-441-3000. We have about 20 more minutes left of the show. And Lori Robinson, who is a board-certified civil trial attorney. I didn't get to mention that. I always like to brag about her a little bit about that. There's only less than 3% of all attorneys in Florida are board-certified. And our firm is blessed to have 2 board-certified civil trial attorneys. That's Lori Robinson and Brian Caulfield. Many firms don't have any. And so our firm has 2 of the less than 3%. So it takes a lot to be board certified. And so Lori's here to answer any questions that you have regarding our areas of law. Lori does a lot of Social Security disability with us. Mm-hmm. We all do personal injury and also workers' compensation. And as Lori was talking about, a lot of times our cases, they all commingle.
Yes.
An auto accident case and a Social Security disability case or a Social Security income case and a workers' comp case. In fact, we had a case where a gentleman of ours tripped and fell on a sidewalk, and we fought the premise liability case because the defective sidewalk. Mm-hmm. But if we didn't also do Social Security, it could have had dramatic impact on him.
Yes.
Can you tell our listeners a little bit about, without giving too much information, but enough so they understand the situation?
So you can have situations where a person is receiving Social Security disability or SSI, which would be the more problematic one for our purposes. So if you have something happen and you have a claim and you're able to be successful in making a financial recovery for that claim, then if you're on SSI, that's more of a welfare type of program. So if you receive money, then that's going to reduce and eliminate, if it's much money, your right to those benefits. Now, in one way, that was your first thought would be, well, okay, fine. All right, I don't need it, right? But if it's a situation where you have an ongoing disability, you get a settlement, but it's not going to last forever.
Right.
And if you're off disability, if you are knocked off of that, then you've got a whole situation with how are you going to get back on? And yes, you may be able to, but it's a whole process. So in a situation like that, because we do Social Security disability, which would involve both the disability program and the SSI one that I just mentioned, we're tuned into that. So in that particular case for the gentleman we represented, it made more sense to have a special trust arrangement, and there are particular provisions. So we worked with a lawyer that is a specialist in setting up what they call a special needs trust, and that will protect this gentleman for the rest of his life, really. I mean, he will have the benefits that he needs. His benefits continue, but then the trust will make sure that additional things he may need are available to him. And it's something that has specific requirements that Social Security has established, and it's a pretty sophisticated thing. Yeah, but very
also protect his medical insurance as well.
Right,
he would have lost his medical insurance.
Yeah, he lost his medical insurance, and so the law is. It's unbelievable how complicated it is, which, I mean, people know that. I mean, I say as a lawyer of 45 years, it's like, I think I love learning. It's like it never stops.
That's right.
It's so complicated. So I love that our firm does all areas that would touch personal injury matters. I mean, that basically is what it boils down to. And I feel much better as a lawyer to be knowledgeable about all of the things that would involve that would touch on issues of a personal injury of some type.
Oh yeah, and just yesterday or the day before, I guess it was yesterday, since it's only Tuesday today.
Somehow it seems. Well, I guess it was a long weekend or something.
Yeah, just yesterday, our partner Brian Caulfield came to me and he was talking about one of his clients who just had a deposition, and he was involved in an automobile accident. They were asking him about his Social Security disability income and such, and the client was like, "Oh my goodness! Now they're asking me all of my Social Security disability. I'm going to lose my Social Security disability." Can you explain to our listeners, the difference of the impact a settlement has if you're collecting SSD as opposed to if you're collecting SSI?
So that's a very common misunderstanding. I would say practically every person, until they ask and are told, will have it. So if you are on Social Security disability, that means that you worked recently enough to the time that you were found to be disabled, that you are getting your Social Security retirement early based on the medical issue. You can be a millionaire, a billionaire. There's no income aspect of that at all because you paid into the system, and under their rules and their little aspects that are complicated, but basically you paid into the system, so you don't have any worries about income if you are receiving Social Security disability. The other program, there can be a situation where maybe the person has had various issues, so they haven't really worked enough to pay into the system, or they did, but it was a long time ago, and quite a bit of time went between their last work and when they were qualified. And so they only qualify for the welfare version of that program, which is called SSI. So totally different situation. So if you're receiving Social Security disability, you don't have to worry about income.
Right.
Now, if you are working, that's a different thing. If you're earning wages and you're able to earn more than currently $1,550 gross in a month, then that would show you weren't disabled. So that's a whole different thing. But if you receive, income from some investment or you get a settlement, you don't have to worry about that if what you're receiving is Social Security disability. But many times people aren't really sure what they're receiving.
That's right. That's why I had to ask Brian. So, are you sure it's SSI or SSD?
Yeah.
And he said it was SSD. So, So the benefit of us doing Social Security disability claims as well is that we can educate our clients in our personal injury cases as well, and also in our workers' comp cases as well. Because in our workers' comp case, we've said the wages can end once you reach maximum medical improvement unless you're permanently and totally disabled. And then your wages can continue if you can prove that you can't go back to any sedentary job. Well, you may also be entitled to Social Security disability if you're not able to return. And so the play between Social Security disability and workers' comp can be very confusing, and it's very case specific.
Right.
And so that's why it's important that whoever's handling a workers' comp claim, whoever's handling a personal injury claim, whoever's handling a Social Security claim with any one of the other aspects, understands how they interplay with each other.
Yeah, it almost makes me think of the way our medical system has gotten. So you have a doctor for each specialty, and unless you've got, would probably be your family doctor, internal medicine doctor, somebody who really, and even then, who really is monitoring all the different medications you're getting. I mean, one hand doesn't really know what the other is doing. So it just gives me a comfort level that when we're representing people, we do have great experience in the whole field that's going to deal with the types of issues we're talking about, because it is complicated.
Right.
I just recently had a legal malpractice case, not going to go into any issues, but it's one where the attorney made an error about a benefit for Social Security. And I totally understand how the error could be made because it is such a convoluted system and trying to read and understand what they mean. But you're the lawyer, you're held to the responsibility to get it right.
Right.
So, but it's a complicated area. So it's a benefit that I appreciate in being able to advise our clients, because many of the clients that we see will have a potential issue regarding their eligibility for Social Security at some point, and it interacts all the time with the workers' compensation claimants. So it definitely, all of these things have their role, and they all kind of come together. So it's good to be able to advise people with the benefit of knowing how all that works.
Yeah, you can't ask me how to. I can't tell you how to draft a will,
no.
or what what criminal penalties are, or anything like that. But if it's personal injury, workers' comp, or Social Security disability, we know our stuff on that respect, and we make sure we refer out all those other ones to other attorneys who do understand that.
Absolutely, because just kind of obviously in the medical world where everything got specialized, the law is very much that way now too,
right?
And has been all my career, really very specialized. So I wouldn't begin to try to do a living trust or a will or something of that nature.
That's why it drives me a little bit crazy that there's some attorneys that do criminal law and personal injury. You either have to be all in or
there can be a few things you miss that you don't realize you're missing.
Right.
Obviously it's going to depend on the individual, I'm sure. But
as you can tell, Lori is much more politically correct than I am. So I just think it's important that you want to be represented by the most knowledgeable, the one who's focused on that area of law the most.
Well, and I think a lot of what happens is, so if you're a criminal, the only other area that involves trial practice really would be personal injury. But the reality is, we have a large firm, well-established firm. We can handle going forward in a trial if that's what needs to happen, and the insurance companies know we will.
Right.
But very few cases in the long run go to trial, and that's so right. I think what ends up happening, and it will, is attorneys will kind of dabble in it a little bit. Think that you can get the case settled, which, it's not that you can't. And sometimes, we work with a lot of lawyers that they don't really want to go into court because that does require quite a support staff and operation. So they'll handle a case, and if it can't get to resolution, they may refer it to us as trial counsel.
Right, and then we handle it. Yeah, I think that's good. Well, we have about 7 more minutes, and every week for the past year, I've always said we have to talk about uninsured motorist coverage.
Yeah, there we go.
We only have 7 minutes, but you got to experience a situation today that made my head spin, but it is a classic, case
situation.
Why you need uninsured motorist coverage. Can you tell our listeners about that?
And so we were involved in, this is a very common scenario, but this was such a tragic one where it was a multi-car accident. And the person that caused the accident, very limited insurance. They had, basically a total of $20,000, $10,000 per claim. And there were, I'm just going to say, 4 claimants, people that had, pretty significant injuries. Some very significant.
Right.
And so in that situation, the insurance company, to be honest, they don't really care. They just want everybody to sign off, so they pay out their policy. And their obligation is done. So you've got, and here's a situation, not one person in that group had uninsured motorists. And one of the ladies that commented, I sure will now,
right.
Because what happens, people just don't realize you can get involved in a situation like that. And if the driver, so this driver had more than full coverage, so it wasn't very much.
Right.
But it was actual liability coverage that would cover. But when there are a bunch of people that have been hurt in the same accident, then it doesn't go very far. And obviously, this wouldn't go very far at all. So that's why you always want uninsured motorists.
Yeah, because bodily injury liability coverage is not required in the state of Florida.
No,
so
and a lot of people don't have it.
I think the last study I saw was about 1/3 doesn't have any bodily injury liability coverage.
And then those who do. How much
this driver,
right.
she
10,
had
20,
10,000, which is the bare minimum you could have.
And imagine, let's say that they had 2550. That still would not have covered the claims we had in this particular.
There were broken bones all over the place.
Extensive hospitalizations.
Cars flipped, right? In that situation.
Right. And the other thing people don't realize, your insurance people won't necessarily be tuned into why this is important. They'll say, well, you've got health insurance. Health insurance, that's helpful for your medical expenses, but those are not the only things that happen. You may have a job loss. You may lose significant income. You may end up having to lose where you were staying, which there was a sad situation here where that happened, where the people had lost quite a bit of money for where the person had been staying. All of these other types of damages that are not necessarily your health insurance, that there was a great need for financial help on. Nothing.
And health insurance only. You still need your deductible.
Right. You still got a lot of co-pays, and there are things it doesn't pay for.
Right.
And then the other thing, I would just end on this note, because, we're what ends up happening, you ask a person what type of coverage they have, and their initial response is you say, well, now, do you have uninsured motorists? Oh, I'm sure I do. Because no one, unless you go through something like this or you're a lawyer that does personal injury, you would have no reason to really even understand what it is, frankly.
I had that discussion probably with three different people in the last 2 days saying, oh, yes, I have uninsured motorist coverage. And then I said, okay, well, let's get on your app. Let's see what coverage you have. And sure enough, one didn't even have bodily injury liability. She said, oh, I was told I had full coverage. I said, well, let me show you what full coverage means. And sure enough, it was PIP and property damage. And that was it.
Yes. So it is
very
so
important. Check your policy now before a crash to make sure you have uninsured motorist coverage, because 66% of the people driving on the state on Florida's roads have $10,000 worth of bodily injury or none. And so uninsured motorist coverage is the only coverage that really protects you and your family.
Right.
And so it's so important to have. It almost wraps up this another edition of FLA Law on the Radio. Lori, if people had questions for us that's not between 5 and 6 o'clock on Tuesday, how can they reach the attorneys at our firm?
Well, of course, you can always call the firm at 727-796-8282, or the easiest way these days, Google, and just go to our website, which is usalaw.com or voiceoftheinjured.com.
We have both now.
And either place will get you to our website, where you have a lot of information and opportunity to fill out a contact form if you wanted to.
Yes, and we're here. We're here to answer questions that you have. I mean, whether it's here on the radio or here in our offices, we like to meet with people. I see these commercials for other firms saying, well, I never even had to meet an attorney. I said, well, that's horrible. That would be horrible service if you never met your attorney.
Yeah, I would say now we're up to date, so now we can do all the DocuSign stuff if that's how people would like to do it. And, it can be efficient initially, but I'm a great believer. The human contact is very good.
Yes.
If you don't want it, okay, but I think it helps us.
Zoom and such like that.
Right, but it does help us to help you, the injured party, I think, to have more of a personal touch.
I agree 100%. So if you have questions, call us at 727-796-8282 or visit us at voiceoftheinjured.com. I'll be back next week. That sounded like Arnold Schwarzenegger. I'll be back next week with bankruptcy attorney Jake Blanchard. So get your questions ready for Jake and myself. But in the meantime, thank you for listening. I always encourage you to drive safely and to watch out for those who don't. Take care.